Hello, everybody. Thank you for coming. Welcome to our first sort of law school session, and welcome to University Open Day. It's nice to see so many people here interested in law. My name is Scott Optican. As you can see, I'm an associate professor at the law school. As you can hear from my accent, I'm from the South Island, that being the South Island of California. Although I have actually lived here for 30 years. I'm a New Zealand citizen. I've got 2 Kiwi American children. My wife is a healthcare lawyer for Te Whatu Ora, and I am an associate professor at the law school. I teach evidence, criminal procedure, criminal justice, police powers. So I teach all the cops and guns and drugs and robbers stuff that you see on TV and read in the media. And I sort of write in that field as well. I've been a consultant for the Law Commission. I do a certain amount of media on crime and justice issues in New Zealand, and I've been doing that for a while. I am an American, but I'm a New Zealand citizen as well. I did my undergraduate degree at the University of California, Berkeley, in San Francisco, where I did rhetoric and legal studies. I then went to the University of Cambridge in England, where I did my master's in criminology. And then I came back and I went to Harvard Law School, where I did my JD degree, and I worked a little bit as a prosecutor in the New York County DA's office, some white-collar criminal defense, some civil practice, but I went into teaching in 1992. And because I had degrees from England and the United States, I was a kind of a good expat hire for Auckland University. So the law school actually hires quite a few people from different common law countries, South Africa, Canada, the United States, and of course, many from New Zealand as well, and England. And so my job here today is to just do a couple of things. I might talk for a few minutes about what it means to study law and the decision to study law. And we've got plenty of law school advisors and people up there in the foyer upstairs to give you advice about that. You've all got our latest brochures. But I might just talk for a couple of seconds about what it means to study law and the decision to study law. And then if you'll permit me, I'm going to do a little simulated law school class with you. I'm going to do basically what would be a first-year class in criminal law on one of the most famous English criminal law cases in all of history, a case called Queen against Dudley and Stevens from Victorian England. And the title of the case is Hungry for Murder. Another title of the case might be, When Can You Eat Your Friends? Or When Can You Eat Your Shipmates? But we'll get to the case in a second. First of all, just very quickly about studying law. Obviously, everybody's here because they're interested in studying law or doing a law degree, and that's really great. And all of you have seen a lot of images and things about law on television and movies, you read in the media. Some of it's true, a lot of it's not. People come to study law for various different reasons. And I think my own perspective is, and having counseled students on this for many, many years, instead of saying to yourself, do I want to do a law degree? Do I want to study law? I think a better way to approach it might be to ask yourself, what kind of person am I, right? What am I interested in? What am I willing to do? So what are the characteristics of a good law student and someone who's good at studying law and someone who might be a good lawyer? Okay. First of all, there's a lot of reading and writing involved. It's still a word-based business. So there's a lot of reading and writing involved. Now, many people are very good at reading large volumes of material and they like writing, and some people aren't. Some people have different sort of skill sets. But there's a lot of reading and writing in this business, in being a law student and being a lawyer. So ask yourself, are you someone who's good at reading lots of material? Can you digest material quickly? And do you like to write? Are you a good writer? Okay, and is that something that's part of your skill set? So reading and writing is something you should be thinking about if you want to be a law student. The second thing is are you a sort of a public person, right? You see me, I'm standing up now in front of all of you. I've got no notes, pretty confident, I feel good about this. Lawyers get paid to basically talk. They get paid to open their mouth and say stuff. Whether it's in front of judges or juries or clients or meetings with partners, we are mouthpieces. That's what we are. We represent clients, we represent the government, we represent criminal defendants, and so we get paid to talk. And so law is a bit of a public profession. You have to be someone who's willing to get up and talk, and get up in front of an audience. Now, that is unless you're a tax lawyer or a gifts and estates lawyer, in which case you just deal with numbers and dead people. So you could go into that area of law. But most law, okay, involves kind of talking and getting up and being a sort of a public person. So, some people are not, that's not everybody's skill set, but if you're a sort of person who is willing to get up in front of an audience, who wants to have your say about something, that's an important part of being a lawyer as well. The next thing is you really have to be someone who's willing to work at it. I mean, this is still a business that very largely depends on kind of hours worked and the amount of time you put into a case, right? So it is a lot of effort. There is a lot of work. We still get we work by the hour, we get paid by the hour, we get paid by the case. And so when you're dealing with a case or a big legal issue, there's really not any number of hours you can't put into it. I mean, if you're preparing for trial, for example, there's just whatever hours you have in a day, that's how many hours you'll use. And you may have more than one case at a time. So it is a lot of hard work. So you have to be someone who is willing to kind of do the work and be there and sort of work hard. So you have to be willing to put in the hours and kind of be, have in your head that it is a kind of it is a very person and client-centered business or project-centered business that depends on your effort and your work that you put in on a kind of hour-by-hour basis. The next thing is it's good to be someone who likes to argue a bit, likes to take positions. You're willing to defend your business. I see people laughing out there. You're probably, yes, I've been arguing with my parents for years, with my friends, with my partners. My parents said I was a born lawyer. Like if they told me to go to bed at 8:30, I would say, Mom, there's 3 reasons why I shouldn't go to bed at 8:30. First, and then I would, because lawyers always do everything in threes, right? That's the joke. You always give 3 reasons for everything. So I was a sort of a born litigator, constantly arguing with my parents from day on. We're kind of full at this point. Yeah, sorry, we're just in the middle. You're in the session. Thanks. So that's the thing. It's good if you're someone who's got to take a position and you're willing to argue a little bit, willing to stand up for yourself, willing to advocate. It is an advocacy business, so that's another thing. So if you're that kind of person, that's great. And the final thing, I think, for being a good law student, a good lawyer, is there's no such thing as studying law, right? There's law and. There's law and contracts. There's family law. There's criminal law, so law and crimes. There's law and the treaty. There's international law. There's environmental law. So you got to ask yourself, what is it that you're passionate about? What do you care about? Do you care about families, the treaty, international law, trade, business, right? Intellectual property, AI, the environment. With me, it was crimes. I've always loved crimes. I love crime. I'm really interested in crime. So for me, criminal law was what I did. So I took my interest in crime and I turned it into a law degree, and I basically turned it into a profession, because that's what I do. I teach criminal law related subjects. So it's going to be always law and. So ask yourself, what is it that interests you? And if there is something that interests you, I guarantee you that we have a place for you at the law school, because we teach all sorts of law ands. We teach environmental law. We teach intellectual property law. We teach the law related to AI. And we teach law related to the treaty, and family law, and criminal law, and environmental law, and employment law, and sort of you name it, we do it. And we're coming up with new and diverse topics every day. I mean, law has not even we have not even begun to come to grips with sort of new technological innovations that are going to need legal structures around them. Self-driving cars, for example. What happens when the first self-driving car hits somebody and maybe hurts them or even kills them? Who are we going to put in jail? The hard drive? Right? It's a really interesting question. And so law is going to have to deal with those new structures and new things in society as they come up, and we'll be meeting that challenge. So in any event, those are sort of the qualities, I think, that are important for someone studying law. And so instead of saying, I want to be a lawyer, which is great, or I want to do law, think to yourself, am I the kind of person that's got the right skill set and the right qualities and the right mindset to be in this kind of study and to eventually be in this kind of profession? If you decide to do it, that's great. We've got a lot of course offerings. We've got postgraduate programs. We've got exchange programs. We have a very vibrant intellectual life at the law school. And I've been very proud that our students can handle themselves all over New Zealand and anywhere in the world. We've got students who've gone to the top master's programs in places all over the world. We've got students in top jobs in Crown Law, in the government, and MFAT. Many of our students have become MPs, and they've become, high government officials. And so our students, can really sort of handle themselves anywhere in the world and in any kind of law-related job. And they've done some very significant things. They've become judges and, made a big difference around the world. So we're very proud of them, and I'm very proud of the organization. And that's my sort of little pitch about the idea of studying law and thinking about it and what you might do. Are there any questions about any of that before we sort of launch into the law school class? No questions? All right, that's fine. Like I said, any more you can talk to our student advisors upstairs. All right, let's assume that you're in the first year class in criminal law. And I walk in and I say to you, hi, I'm Scott Optican, give introduction. I say, assuming you know nothing about law, which is a pretty safe bet for all of you in your first day in class, and I'm assuming none of you have done the reading, because that's, also, pretty typical. So none of you have done the reading, you know nothing about law. And I come in and I say, we're going to talk about the most famous case in English criminal law history, Queen against Dudley and Stevens. And this is a kind of a modified version of the case for teaching purposes and for public consumption, but here it is. Dudley and Stevens were a couple of able-bodied seamen. They were merchant seamen, and they were on ships going back and forth in Victorian England when England was kind of the, king of the seas, and they had all the trade routes, and they were the major naval economic power, in the world. Anyway, they get into a bit of a shipwreck. And they end up in a lifeboat. They're in a lifeboat, Dudley and Stevens, with a few other people, and a cabin boy. A cabin boy is like this little 14, 15-year-old kid who signed on to serve tea to the officers and things like that, eventually to get his license as a seaman and become a full able-bodied seaman. But just start off serving tea to the officers. Poor guy ends up in a shipwreck with a bunch of the other seamen in the boat. Well, they figure, okay, whatever, we're in a shipping lane, we'll get rescued. Days go by, week go by, 2 weeks, 3 weeks, nothing. No rescue. You can imagine what's happening. They're running out of food, they can't catch any fish, they got no water, they're all slowly dying in the boat. The kid is actually more far gone than they are, okay? So Dudley and Stevens kind of get together, and this maybe with a couple others, and they go, what are we going to do? We got a problem here. And someone says, I know, let's kill the kid. We'll kill the kid and we'll eat the kid. The kid's going to die anyway. He's the one closest to death. So we'll kill the kid, we'll eat the kid, at least we'll survive. And they go, okay. So they turn to the kid and they say, hey, look, we got bad news. We've decided to kill you and eat you. And the kid's like, oh, I'm not really happy about that, but, you can't do anything about it because you're going to die anyway and you're the weakest. So they kill him. And they kill him and, they begin to do whatever they're going to do with his body to eat him to survive. X number of days, whatever later, it turns out they were rescued. They were rescued. They get back to Victorian England, and this is kind of a big celebrity case, right? They had tabloid newspapers back in those days, and like, oh, how'd you guys do this? This is amazing. How did you survive? And perhaps unwisely, Dudley and Stevens said, oh, well, we killed the kid and we ate him. That's how we did it. And I guess they didn't think there was anything wrong with that, right? However, the government of England took an opposite view. They charged them with murder. Now, if you're asking yourself how that's possible, that little lifeboat is a little piece of England, right? As a matter of international law and maritime law, that little lifeboat is a little piece of England. So English law applied. And they said, that's a murder. These guys get put in jail. Now, you can imagine what the penalty for murder in Victorian England was, right? I'm sure you all know what it was, right? What was it? Death by hanging. In fact, death by hanging was pretty much the penalty for most things. Okay? For most crimes, you could get death by hanging. So certainly death by hanging for this. So these guys figure out they have a big problem on their hands. So they get a lawyer, and the lawyer says, well, the thing is, this is one of those, it's not a whodunit, this case. All the facts were admitted, right? A lot of murder cases are who did it, all right? We don't know who did it. They know who did it. They admitted it. There's no question as to any facts. So the lawyer says, listen, we've only got one chance here, which is what? Well, we've admitted the facts. We can't face on the facts. We need to argue to the judges, to the House of Lords, the highest court in England. Those are the judges with the snoopy ears and the big robes, right? Those guys. Back then, we're going to go to the House of Lords and we're going to bring a legal case that says what you guys did is not murder. We're just going to get the judges to rule that on the facts, this was not a murder. And that's what we're going to do. All right, stop. That's it. What's the first thing you want to know if you're the lawyer in that case? It's the very, very first thing you need to know. Go ahead. What's your name?
Bailey.
Bailey.
Was the first thing that they would need to know is, was the victim ready and willing to be murdered?
Hang on. You're getting a little ahead of yourself. Okay. The answer to that question, by the way, is you can't consent to your own murder. Okay? You cannot consent to your own murder. Yeah. Go ahead. Name, please.
Rosie.
Rosie?
If there was any other Muslim options of getting.
Okay. Hold that thought. You're getting ahead of yourself. They're being charged with murder. What's the very first thing you want to know? Go ahead. Name?
Guilty.
Tell me your name.
Grace.
Grace?
Are they guilty?
Well, okay, you're right. Are they guilty? That's the real question. But in order to be guilty of murder, the first thing you need to know, okay, it's not a trick question, is what is a murder? You know that all crimes have definitions, right? A burglary has a definition. A robbery has a definition. It's written down in New Zealand, something called the Crimes Act. So what is a murder? Did you ever think about what a murder actually is? Can you murder a dog? Can you murder a dog? No. You know why? You can only murder a person under New Zealand law. Okay? You can kill a dog. Can't murder him. Murder under New Zealand law is one of the simplest crimes there is. You need one human being killing another human being, and they meant to do it. That's what murder is. You can't murder someone accidentally. Okay? So, this case, did we have one human being? Yes. Did they kill another human being? Yes. Did they mean to do it? Yes. That's it. That's the end of the case. Some lawyers, you guys are. You're gonna give them advice that you guys are doomed. Sorry, but I'll give you a discount. You only have to pay me half. Half now, half after you're hung. All right? Come on. What kind of lawyers are you? Sure. That they absolutely meet the technical definition of murder. But you've seen enough crime shows to know that just because you meet the technical definition of murder, that's not the end of the story, is it? Because there are defenses to crimes. There are defenses to crimes. All right? Now, just knowing what you know from, having been alive a certain amount and watching enough of this on TV and movies, what are some of the defenses to murder that these guys might bring up? Somebody already raised one, which is maybe he consented. You can't consent to your own murder for obvious policy reasons. And by the way, the kid didn't consent as a factual matter. So there's that as well, okay? What are other possible, in this scenario, what possible defenses do you think these guys might have? You don't need to be a lawyer to do this. This is just common sense. Sorry, what's your name?
Witness? Oh, Melissa.
Melissa, yeah.
What about witness?
Witness? In what sense? Well, no, you don't. The facts are admitted. There's no dispute as to what happened. Go ahead. What's your name?
Macy.
Macy?
The conditions of the murder.
And what do you mean by that?
If the shipwreck kind of drove them a little bit crazy.
Okay, how about this? First defense. They were crazy. They were nuts. And the lawyer says, all right, maybe you guys were nuts. Let me tell you what the definition of being nuts, actually, it's called legal insanity. Nuts is a bit of a common. Definition of legal insanity is you didn't know what you were doing, or you didn't know that it was wrong. Did these guys know what they were doing? Oh, hell yeah. The technical definition, the definition of insanity, if you ever watched the movie Madagascar, is when the animals are hungry and the lion looks at the zebra and he turns into a big steak. Okay, that's insanity. When you look at somebody and you think they're a steak, and so you eat them, that's insanity. They knew what they were doing. Did they know it was wrong? Yeah, absolutely, sure. They said, sorry, we're going to kill you, right? They understood they were killing somebody. They didn't think they were slicing open a watermelon or doing something like that. Insanity is a very hard test to meet. It's a great idea. It's definitely up there. But it's a very hard test to meet because you really have to just not know what you're doing or have no idea that it might be a crime. Okay? No idea that it's illegal or immoral or against any kind of ethical codes. So insanity, off the table. They're not insane. What else?
They had to do it to survive.
Okay, how about this one? What's your name, sorry?
Donovan.
Donovan. How about this one? They just had to do it to survive. Okay? In law, we call that a necessity defense. Okay? The classic necessity defense is, and you see it in different cases. In Australia, for example, you may have seen during some of the Australian fires that they blew up some houses, right, to stop the fire from progressing. Kind of a bummer if it's your house, all right? But basically, as a matter of law, they're not doing anything unlawful. There are times in law where you have to commit a harm to avoid a greater harm. And the law permits that. The classic example in criminal law is the two mountain climbers. One is being belayed by the other, so one's on top, one's on the bottom. The one on the bottom slips, and he's pulling the guy on the top down with him. If you cut the rope, the guy on the top survives, the guy on the bottom dies. If you don't cut the rope, they both die, right? That's an potential necessity defense. You're killing one to avoid the killing of two. All right, now what was your name again, sorry? Donovan. How do you feel about the idea that you can kill someone else who's not doing anything to you to save your own life? You think the law should permit that? Or to save more than one life? Well, it's not a technical question. I'm just asking you what you think as a matter of walking around morality. Well, I mean, you raised it. Do you think we should go for it or not? If you could try. You could try? All right. All right. It's at least saleable. Other views on this? Do you think people should be able to do this or not? There's no right or wrong to this. I'm just asking you what you think. Yeah. What's your name? Mila.
It just kind of reminds me of like the trolley problem thing.
The what?
The trolley problem thing. Of
Yeah.
The morality of like, would you kill one person to save 5 people?
Yeah, this is it's one of the oldest issues in philosophy, but it gets translated here into a real criminal law discourse, right? This really matters to these guys. If you buy this, this might give these guys a defense to murder. If you think people can be in a position to decide who lives or dies to save their own life. Anybody think this is not something the law should recognize? That we shouldn't go this way? I'll give you the other point of view. The other point of view on this one is you can't play God, right? It's not up to you to decide who lives or dies in a case like this. You can't play God. Even though you may want to save your own life or save more than one life, it's not up to you to decide who lives or dies. If you live, you live. If you don't, you don't. You can't take the law into your own hands by deciding who lives and dies, even to save your own life. What do we think of that? Anybody agree with that or disagree? Yeah, go ahead. What's your name, sorry?
Rosie.
Rosie.
Agree.
You agree?
Yeah.
So the flip side of that, and this shows you what a lawyer I am, I can argue any side of an argument. That's good training. The flip side of that, and it's a very legitimate moral point. The flip side of that is that you're asking people to be kind of supermen and superwomen, right? You're basically asking people to act as kind of saints and martyrs, that they should rather die themselves rather than protect their own lives. So the flip side of that is it okay to ask people to be saints and martyrs? Now, you may think, yeah, sure, sometimes you do. Sometimes you have to follow something higher than your own sense of self-preservation. You can't kill someone even to save your own life. The flip side of it is, well, maybe you can, especially if you're killing one to save more than one, right? Which, as you say, that's the trolley problem, and it's an old philosophical problem. So let's at least keep necessity on the table. So consent to murder out. Self-defense, insanity out. Self-defense. No one's mentioned self-defense. What about self-defense? You guys know what self-defense is? Somebody tell me what self-defense is. Yeah.
The act of killing someone to prevent them hurting you first.
And so is this a self-defense case?
No, because wouldn't that technically be classed as manslaughter?
No. That's not. Self-defense is a complete defense. But you had it right. Self-defense is when you get to someone first before they can get you. Why is this not a self-defense case? Go ahead. He didn't do that. What's your name, sorry? Nathan. The cabin boy didn't do anything. He's just lying there. Okay? He was just lying there. So self-defense is definitely a defense to homicide. It's a complete defense. By the way, the actual meaning of self-defense is you can use proportional force to defend against force being used against you. So you can't kill somebody with a machine gun if they're going to punch you, right? But if someone's coming at you with a knife and it looks reasonably like they're going to kill you or cause you serious grievously bodily harm, then you can come at them with lethal force, okay? But the basic point is, and Nathan's right, the cabin boy wasn't doing anything. He's just lying there dying. So self-defense is off the table. Can anybody think of any other defenses that we might have raised? Yeah, what's your name?
Fran.
What is it, sorry?
Fran.
Fran, yep.
That the boy was going to die anyway.
Ah, there's one. The kid was going to die anyway. The kid was going to die anyway defense. That we really didn't do anything wrong because he was going to die anyway. We just hastened the process. What do you think of that? You raised it. What do you think of it?
It might not be the best because I didn't know if he was going to die.
So that's one thing. We don't know. They could have been rescued tomorrow. We have no idea. Okay. The second problem with it, probably the bigger problem with it, is it's still murder. Okay? Just if you kill someone if they have 1 minute left to live, or 30 seconds, or 1 day a week, it's still murder. All right? It's still murder. Because it meets the definition of murder. So it'd be a funny defense to say, well, I killed them, but they were going to die anyway. The truth is, we're all going to die anyway. Right? At some point, hopefully later rather than sooner. So that is not murder. Now, the idea that you came up with, by the way, there's a really much more sophisticated example of that in New Zealand in the physician-assisted suicide legislation, right? The physician-assisted suicide legislation, which was now instituted in New Zealand, is really based on the notion that if someone has a settled, hopeless expectation of death and they're in pain, that they can ask a doctor to help them go in a dignified way, right? So what you just said gets translated into a legal discourse in that sense. But that's legal because it's been made legal by legislation. Otherwise, it would be a murder. Otherwise, if a doctor helped you commit suicide, that is basically an accomplice to a killing, to a murder. And that's why the legislation is there. But it's a very different context than this. But that's a good idea. I think we've got them pretty much all on the table. All right? Consent to your own killing, you can't, and he didn't. Would have died anyway, still a murder. Okay? Doesn't matter. Self-defense, nope, kid wasn't doing anything. Insanity? Not really. They made a conscious choice to do what they did to save their own lives. The only thing left on the table was necessity. When they ticked all the boxes, necessity. And that's exactly what went up to the House of Lords. The lawyer got up there and they said, we don't need a trial. We don't need a trial. The facts are admitted. We want you to rule as a matter of English law, okay, that in a situation like this, when they killed one person to save more than one, that is a necessary act, and it is a full defense to murder. And that was the argument. And you can go look up the case. You can read it if you want to read the judgments. There were dozens of pages of judgments from the House of Lords. You know, they vote as a majority. How many people think that the highest court in England, in Victorian England at the time, ruled that necessity was a defense to murder? That what these guys did was okay, and that they were not guilty of murder? Raise your hand. Raise your hand on a few of you think that they went for it. How many people think they didn't go for it? They said it's not a defense to murder. That's the majority of you. And then the rest of you in the middle? Not sure. All right. Before I do the big reveal, laboratory demonstration. The fact that some of you think it's a defense, some of you think it isn't, some of you aren't sure, what does that tell you about law? Any hard question in law doesn't have an easy answer. If it has an easy answer, it's not a hard question, and it's probably boring. Right? Law is about morality, common sense, justice, and people differ on that. There is no right or wrong answer to this. In the end, the judges who have the power get to make the decision. I won't keep you in suspense any longer. The Privy Council ruled pretty much unanimously that necessity is not a defense to murder in New Zealand, in England. They said it isn't. They basically said that people cannot play God, that you cannot kill one to save more than one, so that's how they solved the trolley problem, and that was the decision. That was pretty bad for Dudley and Stevens, because immediately after that, they would have been sentenced to death. However, ain't over. The story's not over. Now, Queen Victoria, okay, not a stupid monarch. Okay, one of the great ones, really. Not a stupid monarch. When these guys were sentenced to death, there was a bit of a public outcry. There was a bit of a public clamor. The media got a hold of it. There was a bit of a public clamor. And many people in the public were not happy about this. They didn't think it was fair. They didn't think it was right. They thought to themselves, what would we have done in that situation? Might we have done exactly the same thing to save our own lives? Many people in the public thought that you don't have to be supermen and superwomen, you don't have to be saints and martyrs, that these guys didn't do anything wrong. But the judges thought they did and sentenced them to hang. What can the head of state, a queen, a president, a prime minister do in a criminal case when someone is convicted to change things? Nathan, do you know? They can give a pardon. Have you heard about this? The pardon or commutation power. This is something that exists in the common law world and in other countries. And kings and presidents and queens and heads of states can pardon you for a crime or commute your sentence. Queen Victoria listened to the pulse of the public out there, and she wasn't stupid. And she basically said, I'm going to exercise my discretion as the monarch to have these guys not hang. They ended up doing a couple of years to make it look good, you know, prison-wise, and then they got out. They were not hung. And that was actually considered to be a very just and wise decision by the members of the public, even though it disagreed with the judges. Now, what does this tell you? Again, with hard questions in law, there are no easy answers. Your views on this are just as good as anyone else's. In fact, all the questions and the points of view you came up here with no legal training is exactly the kind of things that lawyers argue. So there's not a huge amount of difference often between law and people's sense of morality, notions of common sense and justice. That's where it comes from. Okay? So always have your own views on this, and remember, in any hard case, people will differ. The second thing is that there are different centers of power in law, right? There are different centers of power in law. There are the police that charged these guys with a crime. There are the lawyers that defended them, the judges that made the decision, and then ultimately the queen who pardoned them. There are different players in law who exercise different kinds of power. And finally, the real moral of the story is that sometimes the true definition of justice, okay, is law tempered with a sense of mercy, right? That's what happened in this case. You had a legal ruling tempered with a sense of mercy by the Queen to achieve what many people thought was a more just outcome. To this day, the law in England is necessity is not a defense to murder. The law in New Zealand is necessity is not a defense to murder. You know what the law in the United States is in many jurisdictions? Necessity is a defense to murder, right? And in other countries, it may be as well. Again, it just goes to show you where a case starts, where it ends up in different countries, and how it morphs is, you know, a movable feast. That's it. It's just right on bang on 10 o'clock. If you enjoyed that, maybe you'll like law school. Thank you very much. We hope we'll see you around. And I appreciate it. You've been a nice audience. Thanks. All right. Enjoy the rest of your day. Bye-bye.